hear me now?
Yes, I can. Was that?
Can you hear me?
I can.
Great.
Awesome. So Roselle, I can hear you. Avnish, was that you chatting just now?
Yeah,
That was
yeah.
also me, Aaron. Sorry, just to make sure, can you hear me, Aaron, as well?
Aaron, I can hear you. I can't see you at the moment. If you'd like to maybe navigate to that bottom bar. Oh, perfect. There we go. So I am seeing you now, and I believe that this is everybody in this session.
I may as well do Soundcheck too. Can everyone hear me?
Yes, Gerald, we can hear you great. So you'll see in that little purple preview box at the bottom the way that we have all of the speakers sitting on screen here right now. We're hoping to avoid having this whole large group sitting there throughout the entire session. What we're hoping to do is have the speakers that are on screen in that given moment where they're either delivering remarks or doing that Q&A are the only ones with their camera and mic on. So to walk through that process, I know that at the beginning we will have Joanne delivering some welcome remarks and a land acknowledgement. When Joanne is doing that, what I will ask is that everybody else in this session, please mute and turn your camera off. As a quick example, I'm going to turn my camera off and you'll see what will happen. My image disappears. I'm still in the room. If you look at the preview box on the bottom, you won't see it yet because there's a little bit of a delay, but you should see my video disappear off screen. And then in that case, we will only have the one speaker of the moment. To make sure that we're transitioning properly from, for example, Joanne's remarks to the later session, I will ask that Joanne invite the next speakers to turn their cameras on. In that case, it would be Roselle and I believe Emily for that first Q&A. So Joanne will mention that she's turning her camera off and inviting Emily and Roselle to turn their cameras on. Emily, once you're finished answering that initial question, we'll ask you to turn your camera off and invite Avnish to turn your camera on, and so on and so forth. So Avnish, you would turn your camera off once you're finished your remarks and invite Richa to come on screen. Does that all make sense for everyone?
Yeah, just the order is reversed, so it's
Okay.
going to be Avnish first, and then Emily, and then Richa.
Avnish, Emily, then Richa. Okay,
Yes.
Got you. And then Gary, you will come on screen at the end with all of the speakers to answer audience questions, correct?
Okay.
And so in that case, once the last speaker has finished, Gary will have you turn your camera and mic on, and all of the previous speakers will come on as well. That is not including the speakers for the second half of this panel. When we reach the second half, we'll follow a similar protocol. Gary, once the Q&A is over, and I will be communicating with you through private chat, just sending you a test message here so that you can see it, test.
Yeah.
We've got it. Perfect. I will also be signaling when we're winding down on time so that we can respect the time for the second half of this panel. Second half, Julia, I believe you will be the only one on screen. So Gary, once we wrap up your session, please turn off your microphone and camera and invite your fellow speakers from the first half to do the same. You're welcome to stay in this room, but just please remember to stay cameras off, mic off, so that we can get the other speakers up on screen. For the second half, I believe, Professor Lan, you will be speaking with Professor Lee, and Aaron, you'll be facilitating that conversation.
That's right. Gabriel, could you do me a favor? Could you test how you would send me one of the Q&A questions so I can see where it appears on this page?
Absolutely. I'm glad you've asked. Let me just send you a quick test message here. Sending a test. You should see it pop up on the top of your screen there. Are you catching that at all?
Okay, got it. I saw that. Yeah.
Great. Okay. Are there any questions here? Okay. If not, what I will, oh, sorry, Joanne.
I was just saying maybe we all coordinate that at maybe 5:04. We all turn off our camera and then I just come on right at 5:05 to do the introduction.
Yes. So, Joanne, what I might suggest is that everybody except yourself turn off their mics and cameras, waiting for your direction to call the next two speakers on. Reason being is so that we do have a face on screen when we do go live to broadcast. And since you are the first speaker, we'll just have you be the only one on camera. So with a few minutes remaining, and again, if we start a minute or two afterwards, it's not the end of the world. I will ask that the other speakers here, please turn off your microphones and cameras.
Sorry, I'm just doing a quick test. Can you hear me? It's Angela.
Yep, Angela, we can hear you great. Thank you. Awesome. So it should just be yourself and myself right now, Joanne. I'm going to turn my camera off. So it will just be you on screen in a moment. The preview box that everybody is seeing in the bottom right hand of the screen, it is about 10 seconds delayed from what's going live to broadcast. That's not to say that anything that you're saying will be delayed. That is only to say that before you deliver your first remarks, Joanne, and this is only for Joanne as our first speaker, please hold for 20 seconds. If you could count 20 seconds in your head once I give you the go-ahead that we're going live, then you can begin your remarks. Does that make sense for you?
20 seconds?
Yeah.
Okay.
So I will give you a heads up when we will start that. Okay, so just to our other speakers here, I know you're not on camera, but you should be able to hear my voice. I will be muted and cameras off for the rest of the session. Please keep an ear out for the direction from the speaker prior to you, indicating for you to come up on screen. And for the speaker that is finishing their remarks, please remember once you finish speaking to turn your camera off and your microphone off after that. Are there any final questions before we move forward to take this live? Hearing none, I'm wishing you all the best of luck. Thank you again for joining us. We're very much looking forward to this conversation and appreciate all of the time and effort that you've spent making this possible. So thank you all and good luck.
Thank you.
Joanne, you can start that 20-second countdown now.
Hi, everyone. My name is Joanne Sang, and I'm Legal Counsel and Director of Development Administration at Ryerson University. It's my honor to welcome you to the panel on legal education and anti-Asian racism in the legal system. Let's begin with the land acknowledgements. The land we are standing on today in Toronto is in the Dish with One Spoon territory. The Dish with One Spoon is a treaty between the Anishinaabe, Mississaugas, and Haudenosaunee that bound them to share the territory and protect the land. Subsequent Indigenous nations and peoples, settlers, and all newcomers have been invited into this treaty in the spirit of peace, friendship, and respect. This space at the National Forum will be inclusive and safe. By participating in today's event, you are agreeing to recognize our starting point, acknowledging and recognizing that we must all strive to overcome historical and divisive biases. Treat all people with dignity and respect, trusting that everyone has come to the forum to learn, grow, and share. Be open to learning, recognizing that the best way to understand the choices, actions, or intentions of one another is by asking questions. And care for ourselves and each other, acknowledging that heavy conversations can impact our mental, spiritual, emotional, and physical well-being, and that it's okay to ask for help and support. Now on to the main event. For this panel, several distinguished and accomplished speakers from public and private practice and Ryerson University will engage in dialogue and shine a light on some of the connections between anti-Asian racism and the law. Some of these connections are visible, and some are much more hidden, but equally impactful. The following conversations will cover effective advocacy for racialized groups, case law about anti-Asian racism, and tools for educators to address this issue. For our audience today, we hope that listening to and learning from the speakers will raise awareness about anti-Asian racism in the justice system and education sector. We hope that it will prompt questions about the status quo and encourage you, the audience, to think about how to take meaningful action to combat anti-Asian racism and build solidarities. The first topic for this panel is on advocating for marginalized, racialized groups, to be followed by a discussion on anti-Asian racism resources and legal education. Our next speaker, Roselle Kim, is a staff lawyer at the Women's Legal Education and Action Fund. It's a national charitable nonprofit organization that seeks to advance substantive gender equality through litigation, law reform, and public education. Roselle, over to you to introduce and moderate this important topic. Thank you very much.
Thank you, Joanne. Can you hear me?
Yeah, we can hear you.
Great. Thank you, Joanne, for that introduction. Good afternoon, everyone. My name is Roselle Kim. I am joining you also from the city known as Toronto, which comes from the Mohawk word Takaronto, which means a place in the trees, place where the trees are standing in the water. The first part of this session will examine barriers that exist in the legal and social systems for low-income folks and how the law can be used as a tool for systemic change. And of course, we can't examine these systemic barriers fully without reckoning with the colonial system and the laws that built this country that we now know as Canada. So I invite us to reflect on our ongoing colonial legacy as we engage in this discussion. So I have the honor of moderating this discussion on advocacy for low-income racialized communities. And the objective of this discussion is to create space to discuss systemic nature of racism, where we tackle how the law can represent an oppressive force that poses barriers for people living at the intersection of race and poverty, and also how it can be used as a tool for addressing those oppressive conditions. With that, I'm excited to introduce our speakers, and I will invite them to turn on their cameras when I call on their names. So the first speaker is Avnish Nanda, who is a public law litigator practicing in BC and Alberta. And the second speaker is Emily Lamb, who's a partner at Kastner Lamb, a boutique litigation firm in Toronto, specializing in criminal, employment, and civil litigation. And finally, we have Richa Sandel, staff lawyer at the Don Valley Community Legal Services in Toronto. And she was also a co-planner of the session and is a member of the Legal Steering Committee. We also have Gary Yee, who will be moderating the Q&A portion of this session. Gary is currently the interim executive director of the Chinese and Southeast Asian Legal Clinic, and also a member of the Legal Steering Committee. I encourage you to check out the full bios of all the speakers by visiting the National Forum website or the speakers page on FeedLoop. And I'll now begin the discussion. So I want to ask the first question to Avnish. Avnish, your practice involves representing clients from marginalized communities who want to hold institutions and systems accountable. How do you build a practice focused on serving marginalized communities? And does your lawyering and advocacy need to be different in any way from a traditional litigation or private practice?
Thank you, Roselle, and thank you for you folks for putting this on, Joanne as well as my co-panelists, and Gary for being part of this discussion. I'm coming from Treaty 6 territory in Edmonton, and I'm thrilled to be here to have these discussions. I think for a practitioner, particularly a practitioner that works with marginalized folks of all backgrounds, of all circumstances, I think theory is important. I think knowing what you're doing and why you're doing it is critical. And it's something that I've been struggling with or trying to come to terms with throughout my years of practice. And I've come up with this theory or this understanding of how to do this type of work in an informed, engaged, collaborative manner that hopefully helps folks who need that help. And my theory is this, is that I've come to view law as a public space no different than a community park or kind of a civic meeting space. The law is a public space that occupies both the conceptual and physical location within our society. It not only consists of the rules that we are to live by and how to interact with each other and the state, but also provides kind of the institutions where law is made, law is adjudicated, law is determined. And if you view law as this public space, and you work with marginalized folks, you'll know that although the law touches us all, it encompasses us all, it's not designed with all of us in mind. It doesn't reflect our stories. It doesn't allow access to it for certain folks based on identity markers such as kind of race, class, ethnicity, and a range of other factors. So with that in mind, how I view law in terms of representing folks from marginalized, vulnerable backgrounds is how to increase access to this public space, how to ensure that the law reflects their lived experience, and ensure better outcomes for them. And another kind of approach or theory that I've come up with is, what my job is as a lawyer. And my job as a lawyer is nothing more than translation and navigation. So as a lawyer, what I do is I translate the law into the lived experience of my clients, and then I translate the lived experience of my clients into the law, and then help them navigate the institutions of the law to ensure that their story is reflected in the law, that the law accounts for their lived experiences, their aspirations, their hopes, and to ensure that they're able to use the law in a dynamic way that they can improve their lives, or at least address the situation in front of them in an equitable manner. Because for many marginalized and vulnerable folks, the law is something that's done to them, right? It's done to you. There's no agency over the law. And I really want to ensure that there's agency over the law, that the law is used to not only as a shield, but also as a sword to enhance the lived experience of vulnerable, marginalized folks. And with that in mind, that kind of theoretical perspective in mind, you have to figure out how do you effectively act as a translator or a navigator, how to break down the barriers of the law as a physical and conceptual space, but also to ensure it embodies the experiences of marginalized, racialized folks. And to do that, I think you really need to know and come to appreciate the lived experience of those you're trying to help. And, I'm not saying that you have to live the exact same lives of those folks you represent, but I think you need to go and make sure you understand why a particular issue or why a particular fact is so important to your client, why this cause, is making them put so much on the line or causing them so much anxiety or stress. You need to know, what is driving your client, particularly marginalized and vulnerable folks. And the issue is that by virtue of being lawyers, even though we may have grown up in situations where there's a degree of marginalization, vulnerability based on, being Asian or an immigrant, a new immigrant, I think by virtue of being a lawyer, it kind of divorces us from that lived experience that often the most vulnerable and marginalized clients that we represent face. So there is this gap in being able to fully understand or appreciate where our clients come from. And, I recognize that in the work I do. And also the fact that, being Asian, being South Asian, being, in my case, kind of Punjabi Canadian, there's a diverse range of experiences in those communities itself, that just because I fit the part or check the boxes in some respects, I can't embody or understand the lived experiences of everyone. So I need to really go outside my comfort zone to understand, to listen, to create space for folks to be themselves, to allow me to learn about what drives them, what motivates them, and what they want me to do for them. Because in any kind of legal case, I think we have to work together to achieve a particular outcome. Those are my remarks, and I look forward to the discussion. Thank you.
Thank you so much, Avnish. So now I'll turn to Emily. Emily, you were the lawyer for the appellant, Mr. Lee, in the case of Queen and Lee, which is a landmark Supreme Court case where the court addressed the issue of racial profiling and systemic racism in the criminal justice system. Could you tell us a bit more about the case and about what this decision means more broadly for combating anti-Asian racism and systemic racism generally in the criminal justice system?
Sure. Thank you very much, Roselle, for the introduction, and thank you everyone for having me here today. It is a real privilege to be able to learn from everyone who has spoken at this conference. I am going to actually weave in sort of how I came to be involved with the case and then move on to sort of what this case represents, at least in my opinion. So I grew up in the same community Mr. Lee was from, and it's the Alexandra Park neighborhood, which is in downtown Toronto, not too far from Ryerson. So I was familiar with many of the issues that the community has faced for decades, especially in relation to its relationship with the police. And so it was sort of incredible to sort of get this case, first of all, land on my desk, and then realize that almost 25 years after I had left the community, I was in a position to potentially talk about and get the highest court in Canada to recognize some of the challenges that communities such as the Alexandra Park community faced. So one thing that, you know, in terms of thinking about cases practically, by the time the Ontario Court of Appeal decision was released, Mr. Lee had already finished serving most, if not all, of his sentence. The jail portion, the 5 years, had already been complete. He was no longer in jail. And what you have to recognize is often that simple fact of not being in jail will discourage people from appealing further. At least the practical reality is that there's no point. And oftentimes the system has already broken that person, has already harmed that person. And so the last thing they want to do is continue fighting in a system that has already sort of beat them down. However, you know, Mr. Lee was pretty special insofar as despite his youth, despite the challenges he had faced, not only within his case, but also within the community, he felt pretty strongly that the judge at his trial did not have any appreciation for and had failed to understand the lived realities of growing up in a racialized and marginalized community. And that was pretty significant, at least to me. His friends, there were witnesses called to try to establish racial profiling at the trial level. And Mr. Lee lived through having to not only testify himself about, you know, being carded, being, you know, illegally searched, but he had to hear his friends testify about the same experiences that they had had. And so because of that, because of that experience, you know, Mr. Lee decided, despite knowing that my opinion was we did not have high hopes for winning the appeal at the Supreme Court of Canada. And the reason why I didn't have high hopes for winning is you have to keep in mind, the cards were pretty much stacked against us. We lost at trial and then lost again at the Ontario Court of Appeal. So it's very rare that the Supreme Court's going to reverse those findings. I think the possibility for him of being heard was enough for him to agree to take his case up to the Supreme Court of Canada. And I think understanding that, you know, Avnish just talked about, you know, making sure, I think really the message that he had was you need to listen to your clients, especially clients who have experienced systemic discrimination and are at the intersection of racism and poverty. There are different reasons for why they may want to engage with the system. And you also have to understand what they might be looking for as a result of engaging with the system. So Mr. Lee knew that the chances weren't good. And it was my opinion that we would likely lose at the Supreme Court. In terms of myself personally, as a racialized woman in criminal defense, I myself had never been up to the Supreme Court of Canada at that point. I thought, at that point I was a trial lawyer practicing mainly in criminal defense, but had never really viewed myself as an appellate lawyer or a lawyer who was, quite frankly, good enough to argue at the highest court in our country. So what I did was, this was actually, I think, one of my smartest things that I did in the case, is I asked a very close friend to be my co-counsel, because I knew that she would support me throughout the process, and especially when we were there at the court. And then in addition to that, my second best idea was that I asked 12 of my friends, all of them who I thought were smarter than me, to come and join me as interveners. So there was a lot going on in the case, legally, factually, historically, and collectively. And despite the fact that this was all free, together, I find this case sort of went up to the Supreme Court. And I think that that's how one of the things that this case represents is the collective efforts of many people working together to advance these issues. The other thing, and I know I'm probably running out of time, which is why Roselle is here, is the opening of the door and the court's recognition that social context matters, and how to ensure that both appellate courts and trial courts begin to understand from the defendant's point of view how issues such as systemic discrimination have impacted them. Thanks, Roselle. I think that's it for me.
Thanks so much, Emily. Just a reminder that we are also accepting questions, and we'll be having a group Q&A after we hear from Richa. So Richa, you're an employment lawyer advising low-income clients in a legal clinic based in Toronto. Could you talk about some of the institutional and systemic barriers that are faced by your clients who are low-income members of the Asian communities?
Sure. Thanks so much, Roselle, and thank you, Emily and Avnish, for starting off this discussion so wonderfully. So, I mean, in terms of barriers, there's a few areas I want to focus on. One being economic barriers, just stemming from the fact that poverty is often overwhelmingly racialized. Second, just sort of the lived experience type barriers that Avnish really alluded to. And thirdly, just rounding off and talking about how the legal system and even just basic services that lead people to interact with the legal system are often not inclusive of low-income low-income racialized Canadians, but particularly low-income Asians and South Asians that I work with. So I practice in a legal clinic, which provides free legal services to individuals that are financially eligible in the East End of Toronto. So in Thorncliffe Park, which, if you're not familiar with Toronto, is a very diverse and a very low income area for large parts of the residents that live there, as well as Scarborough, which is also a very diverse community, and with a number of Asians and South Asians present in those areas. In terms of economic barriers, I mean, the vast majority of, all of my clients that need to, that I represent on an ongoing basis, they need to meet certain financial eligibility criteria. So for example, if somebody from a 4-person household wants us to represent them on an employment law or any other issue, right, they need to come from a combined household income of anywhere from, different clinics can set a different, but generally around $40,000 to $45,000, or like a one-person household, if to qualify for our services need to be under $22,000. I obviously represent people, and as an employment lawyer, I'm representing people who are working, who are on these incomes. So off the bat, I'm working with people who are trying to make ends meet in a city like Toronto on wages like these, sometimes for entire families that are certainly less than livable. They're working in precarious work, which is something that I see often happening, particularly with many of the Asian and South Asian clients that I have, in factories, general labor, restaurants, live-in superintendents for whom their employment is also dependent on their housing as well, because if they lose their employment, they also lose their housing, retail, minimum wage jobs. And so when we talk about systemic barriers, economic barriers, the vast majority of my clients who are low income, of the income ranges that I'm talking about, are racialized. And a number of them are Asian and South Asian, especially given the demographics of the communities that I work with. When these workers are coming home, right, at the workplace, you do see that it's quite often that I get cases of racism, systemic, stereotyping, especially in light of the targeting of Asian Canadians during the pandemic. But then they're coming home also to a reality of systemic racism in so many different parts of everyday life. Like Emily alluded to with the Alexandra Park, I mean, Scarborough and Thorncliffe Park, those areas have their own unique issues, but the over-policing remains a concern. Precarious housing, right? They're coming home to situations where in apartment blocks in Thorncliffe Park, for example, it's quite common that multi-generational families, for affordability reasons, will be crammed into one apartment. And then I'm not even going to get into perhaps abuse that might happen from landlords, right? Not following the Residential Tenancies Act. So sometimes even I get clients who I've seen have qualified based on their incomes for social assistance just to make ends meet, particularly when there's a disability involved, right? So there's the irony is that many of these clients are some of the lowest income, but have the greatest need for legal services. So I think what we need to think about then turning to barriers in institutions for them is we really need to think about, okay, what are the smaller steps that we can take to make a system that, like Avnish mentioned, is not designed for them, more inclusive of their experiences. So turning our minds to things like the fact that there are so many individuals in the Asian, South Asian communities that I work with that have significant language barriers. I don't go a day without working with a translator, right? And I'm lucky that that translation service is available through the clinics without cost to clients. Otherwise, imagine if a client was paying for that, right? They'd be priced out of being able to take action. So are we thinking about small things like that, right? Which can make a big difference. Are we thinking about the fact that, we're designing digital first strategies for tribunals right now in light of the pandemic, but a lot of my clients don't even have email addresses, and those that are more precariously housed and perhaps facing homelessness, forget having email addresses, they might not even have a safe place to do a remote video hearing, right? Those are the kinds of lived experiences we need to be taking into account. Those are the lived realities that I'm seeing every single day from my clients, even if they're employed sometimes. And, I think those are all key things that I would hope we're thinking about when trying to design a more inclusive society for low-income Asian Canadians and low-income racialized Canadians as well.
Thanks so much. Thanks so much, Richa. And thank you so much, Avnish and Emily. I learned a lot in this short time that we all had together. A couple of points that I'll just reiterate that spoke to me was just understanding our positions and our different positionality, and also respecting the agency of our clients to know what's best for them. So I'm now going to invite our speakers back to turn their cameras on, and I'm going to hand it over to Gary, who will facilitate the Q&A portion.
Thanks, Roselle. And it really was wonderful hearing from all the speakers. When you work in this area of poverty law, of public interest litigation, it clearly is very fulfilling and it's just so multifaceted, right? We know that when we help clients from racialized or vulnerable communities, that it's more than just a legal problem. We need a holistic approach, and same thing with being a lawyer. That when we try to help individuals, we know it goes beyond just individual cases. So one of the areas that we all work on is beyond individual cases, and it's about law reform. So one of the questions I would ask is if you can talk to the government, provincial or federal, about one area of reform that's needed for the communities you represent, for the clients you represent. What would it be? One area of reform as soon as possible.
Richard or Emily, do you want to go first?
Sure, I have a quick answer. For me, it's the over-incarceration of Indigenous, Black, and racialized people. It is I think, the most pressing issue in criminal justice. I think now the statistics are that 50% of women in federal institutions are Indigenous. That's quite frankly just shameful on all of us. And so I think that is actually one of the most pressing issues of our time, and it is contributing to the violence against Indigenous, Black, and racialized communities, and especially in the intersection with gender and also poverty.
Jagdish or Risha?
Yeah, so I mean, I have a lot of ideas. I think the work is just, there's so much that needs to be fixed. I was happy to hear that they're going to be increasing the minimum wage, so that's something. But I think, if I had to pick one thing, it wouldn't actually be work related, but I would say I would actually be mandating more affordable childcare. And I say that only because I see the ripple effects of the lack of affordable childcare in so many aspects in work. Because people can't afford childcare, women tend to stay home, right? Or alternatively, most people don't realize that they have a tremendous amount of family status protections under the code. But it's in practicality, do they actually use it? I don't know. I've seen so many cases where it's gone south. And employers don't actually know their obligations, right? I've seen a lot of cases of discrimination against women for becoming pregnant, for having children, for having caregiving needs. And I've seen it affecting men too. And I think it also just it's one of those issues, especially in low-income communities who often can't afford the exorbitant fees of daycare, that really causes them to be in a crunch and really impacts the way that they interact with work. I think that it's not a work thing, but it really is a work issue that would make a huge difference if the government were to take some kind of sustainable action on it.
Thanks.
And I'll just be very quick. So I represent a lot of young Indigenous girls and women who are in the child welfare system or adjacently related, and like the indignities and trauma, kind of sexual violence that is routine on a day-to-day basis with no real recourse, no real oversight is just appalling. And I think if you are exposed to what happens in that world and know, obviously the trauma, but also the incredible resilience of these young people and just no real help, I think you'd be motivated to do whatever you can to have any government step up and do what's right in these circumstances. And it's linked to the, over-incarceration, substance use, a range of other factors. But we are systematically and consistently failing young Indigenous folks in this country, all Indigenous peoples, and it's very acutely felt here in Western Canada.
Well, I mean, there's certainly a few of these really compelling issues. Like the numbers speak for themselves. There's real people behind those numbers, and we're all interested in social justice here in this conference, here in this session. So what are, we cannot all work for a legal clinic or do public interest litigation. A lot of us cannot afford to do that, frankly, and it's amazing that we have lawyers who are willing to have those sacrifices to do that kind of public interest work. But for many of us who are just practicing law or being lawyers in different areas, what can we do in terms of getting involved, either in legal work or beyond legal work? What can we do to advocate against the systemic barriers, the systemic racism that's facing low-income Asian communities?
So, I mean, I can start briefly. I think there's a lot to get involved in. There's a lot of organizations, and even the clinics are constantly doing campaigns like fairness at work and fairness, for living wage. But I think there's small ways, even if it's not a central part of your practice, to be part of advocating for change and making sure you're inclusive. The example that I gave about language barriers, for example, is a big one, right? Do you just assume when you're meeting with clients that they're going to speak English, or they're going to have technological preferences? And if they don't, oh, well, it's too hard, right? Do you have access to translation services? Are you making those efforts, right? Because you have to understand this, like, clients, low-income clients, first of all, it's not going to always be an easy experience coming forward with your story. It's alienating if they're coming into a culture that doesn't understand their experiences, and then a culture that's not actively making efforts to include them. And this goes to if you're doing pro bono work, or if you're just trying to market yourself and build your brand and attract more clients. Like there's small things you can do, like thinking about language services, like thinking about, I'm going to be the kind of lawyer that's available to any client regardless of their background, right? Like thinking about, am I just assuming this person's going to have technological capabilities or an email address, right? If you open yourself up to, I think, the experiences of low-income individuals, that's a small place to start.
There's certainly a lot of networking and coalition building that we need to do. We're going to run out of time, but any quick thoughts from Avnish or Emily before we close off? Anything quick?
Sorry, Emily, go ahead.
No, I don't. I was hoping that you would go ahead.
Quickly, so I'm a private bar lawyer who takes on a lot of these cases where there's no money, like no legal aid, nothing, and they're like enormous amount of work. And initially when I started, I had a bit of a chip on my shoulder, like, oh, I'm doing this work, no help, whatever. But I've come to realize that it does take a community, not just the community of folks you're helping, but also a legal community. And I've been really surprised by, if I've gotten into a problem, or if I need support, or if I need someone to, act as a link to the decision maker or a government to get a certain outcome. Lawyers who are in this profession, maybe in a more privileged place, are willing to step up and give a hand, from reading a factum to making a call to just saying, you're doing a good job. Do you need a lunch? Can I buy you a lunch? It's all appreciative, but you don't have to do this day in and day out to be part of the cause, and hopefully people don't feel that way.
Right, that's great. Thank you. I thank all of you for your insight and contributions, and I'm going to turn it over. We'll end this session, and we'll move on to the next part of the session. Thank you.
Good afternoon, everyone. Welcome. I'm Julia Shindoy. I'm General Counsel, Secretary of the Board of Governors, and University Privacy Officer at Ryerson University. It's my great pleasure to introduce the next speakers and facilitator. First, I want to thank Joanne Sang, Ivy Locke, and the Law Steering Committee for all their hard work and leadership in planning today's program. I believe in the power of universities and the law. Universities and the law have the power to respond to societal need and affect social change. Universities in particular advance learning, applied knowledge, and research, and promote the betterment of society. So, how do we best use and leverage the power of universities and the law to combat anti-Asian racism? How can educators communicate the long history and continuing relevance of anti-Asian racism in Canada, including the ways in which it has been enabled and sustained through law? How does teaching and learning about anti-Asian racism and the law help support broader anti-racist and anti-oppression agendas? I will now introduce the speakers and facilitators who have the answers. I invite them all to turn on their cameras. Dr. Angela Lee is an assistant professor at the Lincoln Alexander School of Law. Dr. Jill Lan is an associate professor, Law and Business Department at the Ted Rogers School of Management and the Lincoln Alexander School of Law. Erin Baines is a partner at Aird and Burles and was recently named one of Canada's top 25 most influential by Canadian Law magazine. Over to you, Angela.
Great. Thank you so much, Julia, for that introduction. And my thanks also to the other participants in this session and to the organizers of this event more broadly. My apologies as well if anything I say overlaps with anything that was mentioned in the previous session. I was having some technical difficulties, and so I unfortunately have to miss a little bit of it. But in any case, we are going to switch gears now to talk about teaching and learning about anti-Asian racism and the law. So what I'm going to do is give a bit of a higher level overview of the topic, and then Professor Lan is going to pick up the baton and speak to some more concrete strategies that teachers in a variety of contexts can use for their pedagogical purposes. So there's a lot of important work that's been done and is being done on issues relating to race and racism in a variety of different disciplines in the social sciences and humanities, and of course in settings beyond academia as well. And certainly not to put law on a special pedestal here, but the relationship between race and law is one that's especially significant, because by virtue of its guise of neutrality and the power that it has to order society, law is a potent tool of exclusion. So law both can and has been used to legitimize otherwise racist policies. And legal institutions have played a key role in upholding an unjust racial hierarchy and social order. And Asian people have not been accepted from that process. So that being said, it's somewhat surprising that there's a relative paucity of legal academic literature on the specific ways in which anti-Asian racism manifests and is perpetuated in Canada. And part of the reason for this is that a lot of the existing critical race scholarship has emerged from the context of the United States, where the black-white paradigm is much more of a central focus and has played out in a slightly different way. And another common explanation for why this is the case is that anti-Asian racism is often subtler than the large-scale violence experienced by Indigenous and Black people at the hands of the state. So it can be seen as a form of racism that's less damaging, and it can be subject to erasure on those grounds as well. And to the extent that it is discussed, there's frequently an over-reliance on landmark historical examples like the Chinese head tax or the Japanese internment camps in World War II. And the use of these limited examples belies the fact that anti-Asian racism is not a historic relic, but it's very much an ongoing phenomenon and something that's still happening today. And matters are also complicated by the fact that, at least facially, Canada is a country that very much celebrates diversity and multiculturalism. So at the federal level, we have the Canadian Multiculturalism Act, which explicitly stipulates that the government of Canada recognizes the diversity of Canadians as regards race, national or ethnic origin, color, and religion as a fundamental characteristic of Canadian society. And equality rights are further entrenched in the Canadian Charter of Rights and Freedoms, and also in our various provincial and territorial human rights codes. So on these bases, some might draw the conclusion that racism is not a salient problem in contemporary Canada, especially for certain groups. But systemic racism, including anti-Asian racism, is, again, not something that not only exists in Canada, but is a fundamental part of the country's history. And this has become expressly clear in the context of the COVID-19 pandemic. And we've witnessed this really alarming surge in anti-Asian racism that has served to make visible the enduring nature of it and the contingent nature of the belonging of racialized people in white settler society at large. So at the same time, more attention is being paid to anti-racism and EDI and so on and so forth at various different levels and within different institutions, including at Canadian law schools. But the focus is often explicitly or implicitly on anti-Black or anti-Indigenous racism. And certainly these efforts are to be lauded and they're important, but they can also elide the fact that racism manifests differently against different groups. So against Asian people, against Muslim people, against Jewish people, in addition to Indigenous people and Black people. And critical race scholarship in the Asian context has revealed that the challenges that face Asian people in the Americas are complex and unique, including the way in which the extraordinary diversity captured under the Asian umbrella itself is often flattened, presenting a distorted and essentialist picture of the so-called Asian experience as though it were one singular thing. So the experiences of East Asian people are not the same as those of South Asian people or Southeast Asian people. And even within these groups, there's a lot of diversity that is important. Now, arguably, as the first point of entry into the legal profession, legal education has an important role to play in addressing anti-Asian racism and other forms of racism, as part of this broader project to advance racial justice, combat white supremacy, and dismantle oppressive systems of all kinds. And all forms of discrimination are relevant and useful to this endeavor. And although law students have become more diverse, which is a positive thing, it's not just about who's let in the door of law schools, but also about what happens behind it. So unfortunately, the greater diversity of law student cohorts hasn't necessarily translated to the upper echelons of power, prestige, or pay. And the legal profession continues to face charges that it's exclusionary and classist. And racialized people often recount experiences of marginalization, both in law school and then beyond into their careers as well. And this is poignantly illustrated in a recent documentary, which premiered on November 5th, that was put together by the Federation of Asian Canadian Lawyers, the BC chapter, called But I Look Like a Lawyer. It's freely available to view online. And in that documentary, members of the Pan-Asian legal community share stories of the different forms of discrimination, stereotyping, and bias that they've experienced. So this includes things like not being granted a presumption of competence, having your authority undermined, being asked if you're an assistant, being asked if you speak English, and so on and so forth. And there are a lot of different reasons that we can point to for this ongoing discrimination and stereotyping in the legal profession. But part of the problem very well may be the relative homogeny of law faculty members. And there's no authoritative source of data available on the racial or ethnic identity of Canadian law professors, but a crude visual inspection of the full-time faculty composition at Canadian common law schools, even just through their websites, indicates that Asian people, broadly construed, are few and far between on law faculties. And this underrepresentation is out of step not only with the racial makeup of law students, but also with the racial makeup of Canadian society as a whole. So this is something to be concerned about, because greater diversity and representation in the composition of law faculties can generate meaningful qualitative benefits over and above superficial quantitative ones. So having a range of perspectives and experiences represented enriches contributions to scholarship and service just as it does to teaching. And having different kinds of people represented on the faculty can help demonstrate to students that there is a place for them in the legal profession, and they can serve as mentors and role models to help shape their careers. And so this is something that law schools should be attentive to in their hiring of faculty and staff, not just on the student admissions side. So in my last minute or so here, I want to wrap up and conclude with a couple of main points. Ultimately, the law is not something that is neutral or ahistorical. And members of the legal profession are part of a group that holds a degree of relative power in society. and therefore they have a heightened professional and ethical responsibility by virtue of this privileged position. Consequently, modern legal educators, as people who teach and train future lawyers, must arguably work to help ensure that students are better equipped to serve a range of different populations, especially those that have traditionally been underserved by the legal community. And this is an imperative that speaks not only to social justice, but also to the realities of legal practice as Canadian society becomes increasingly diverse. And this is a trend that's unlikely to change in the future. So as part of this process, it's incumbent upon law professors to teach students about the pervasive roles that race and racism have played and continue to play in upholding institutions of power, regardless of their own position or of their own subject area expertise. And this is something that can be very challenging in many ways, in part because it requires the interrogation of one's own racial identity and our own complicity in upholding various systems of oppression. And unfortunately, many lawyers and legal professionals today are not appropriately equipped to talk about race and racism, both in a substantive sense and in a practical sense. And so this inability to speak in a sophisticated way about the issues can make change really difficult to effect, which is why it's important to have these kinds of conversations and why it's important to try to make a difference for the generations that come after us. So with that being said, I'm going to turn it over to Professor Lan to speak a little bit more specifically about strategies for teaching and learning about anti-Asian racism.
Gerald, I think you might be muted. No, still can't hear you. Sorry, still can't hear you.
Can you hear me now?
Yep, we got you now.
Okay. Sorry about that technical difficulty. Okay. So I'm here to talk to you today about a goal that Professor Lee and myself have, which is to create a set of law-related resources which can be used to teach about anti-Asian racism. And when we speak about educators, not just law professors, but in the broadest sense of the word, although to begin with, we're probably going to focus on law professors because that's what we know very well. So the resources themselves would probably not be anything extravagant. They would be something like just a web page with links and documents that can help. There's no grand vision right now of a stunning website, but it's really about a call to action, even if it is a small step. And so the first section would probably be something about very much about current awareness, to inform others that anti-Asian racism is a very real and current problem. And for that, there may be many other links to other websites that detail this. The second section would be more historical, talking about case law, statutes, and related issues, links to other sources and journals. And the third section perhaps would be something more contemporary, talking about what current laws there might be and current ways of addressing anti-Asian racism. And so what I thought I'd do today was basically walk you through a little bit about how we could use these cases, even though these really old cases, which I believe Angela mentioned, as historical relics, as ways, as tools to talk about how we can have an actionable way forward. All right. So what I chose to talk about today here as a sort of a platform sort of example would be an article that was written called Racism in the Law, the Canadian Experience by Beverly McLaughlin, who is a former Chief Justice of the Supreme Court of Canada. It's a 2008 article. And in that article, although it's generally about racism, I focus on two points that she spoke about. There are these two cases. And so, for example, we may just put these cases on this website, but the value added that I hope to bring would be to tie those cases to the present on how we can take action against Asian racism. So the first case was Kwang Wing versus the King. It's a 1912 case. And what it has to deal with is the legislation that was passed in Saskatchewan that was called an act to prevent the employment of female labor in certain capacities, which on its face doesn't really sound like anything that's necessarily racist. But what was the legislation? It was legislation that prohibited Chinese men from hiring white women. And as Justice McLaughlin said, it was this legislation that gave rise to one of the first Canadian legal cases to deal, or more accurately, to not deal with the subject of race. And we'll talk about that in a second. So in 1912, what happens is Kwang Wing is charged for employing 2 white women, and he's fined. It goes all the way up to the Supreme Court of Canada. And in their decision, they don't even really mention racism. They talk about it as a jurisdictional issue. About, for those of you that are constitutional law lawyers, they talk about the pith and substance, whether the province has the jurisdiction to do this. They make note that Kwang Wing is a naturalized citizen and therefore not like other citizens, and therefore that this somehow justifies the law being allowed to treat him differently. So they uphold the fine against him. In another case, Christy V York, this one is in 1936. Fred Christie, a black man, all he wants is to order a drink in a bar. But then he's told that the bar no longer serves colored people. And so Mr. Christie, understandably upset, sues for $200 for humiliation. Again, it goes all the way up to the Supreme Court of Canada. And again, there's no real discussion about racism or race. Instead, the decision focuses on freedom of contract. That it's not the government's or the court's role to interfere in contractual relations. It's a free market, and so it's all guised in this. So in other words, unfortunately, Mr. Christie does not prevail here. So now this could just easily be a history lesson for the students or for anybody, right? One could easily critique each one of these cases individually, and don't get me started on them because there's a lot to read in them. But each one is also an illustration of racism. But what's really value added here by Justice McLaughlin is the fact that she puts the two of them together side by side. And so the quote from Justice McLaughlin, and I'll just quote here, the Supreme Court of Canada's decision in Christie was not without irony. In Kwang Wing, Mr. Kwang, owner of a small business, was told that the law could discriminatorily limit the manner in which he operated his establishment. In Christie, Mr. Christie was told that the law could not remedy discrimination because it could not interfere with the manner in which the tavern owner operated his business. Or to put in short, in Kwang Wing, the court says, well, the province can regulate your business because it can. It can interfere with your freedom of contract, even though you and these 2 white women consensually entered into an employment contract, it will interfere with it. But in Mr. Christie's case, they said, no, we shouldn't interfere with contracts. So putting those 2 cases together really tells you a lot. Now, I know what some of you might be thinking. You might be thinking, well, these are old cases and they're limited applicability to this day, right, in age, especially when we have the Charter and the Human Rights Code. A couple of points I'd like to say. One is if you take a look at the rise in anti-Asian hate crimes, the problem is still here with us. Racism is still here with us, and there's a key point here from Justice McLaughlin's keen insight. Racism isn't even dealt with in those judgments. Instead, it's cloaked in arguments about jurisdiction, citizenship status, and freedom of contract, which inevitably lead to discriminatory impacts, which in my humble opinion is pretty much the same as upholding racism. So the point with these cases isn't just as a history lesson, or although that is important too, so that people realize that anti-Asian racism isn't just a result of COVID-19, but it's been around here in Canada for a long time. The broader point about putting these 2 cases together, someplace for educators, is that you take a look at these 2 cases, one about discrimination against a man of Chinese descent, another against discrimination against a black man, and you not only see discrimination, but you see the flawed and contradictory reasoning at the systemic level. And in both of these cases, it is no less than the Supreme Court of Canada that is speaking. So it really underscores the importance of understanding racism from a diversity of perspectives from different groups. So again, but isn't that also still cases from a long time ago? True, but the reasoning that was used in those cases still is here today to justify policies that negatively impact racialized peoples. It can fly under the guise of something like public health concern, national security, freedom of choice, which all may seem innocent enough until you realize that there is an impact based upon race. So what about the current laws then? So that was like section 2 of that website or the webpage. What about some important cases now? Well, the two cases above that I just spoke to you, the two cases that I just spoke to you just now, they were about racism and how the court avoided talking about it, spoke about it in other terms, even though that ruling had a discriminatory impact based upon race. Well, let's move now to a case from 2020, just last year. Supreme Court of Canada case, Fraser v. Canada. So in that case, which I consider to be a very, very important case, it's a charter case about Section 15 discrimination. And in that case, it was a case about an RCMP policy where people who took up job sharing, typically due to family and child care obligations, were not allowed to participate in pension buyback, whereas other employees were. So women were overwhelmingly the ones who took part in job sharing. Long story short, because I know we don't have a lot of time, the Supreme Court of Canada found that this violated Section 15 because it had a discriminatory effect upon women, even though the policy itself did not specifically single out women. It didn't say women cannot participate. Its effect was discriminatory because it was overwhelmingly women that were who were the job sharers. And so this is a useful case when you think about the two other cases that I just mentioned. Why? Because even though it's based upon discrimination against women, the ruling is broad enough to encompass race-based discrimination. And more importantly, it talks about the impact. So in those old cases where the courts or other, and it doesn't have to be a court, it could be a politician, a policymaker, circumvents the racial impact by talking about something else. Public health policy, national security or something. A case like Fraser helps reorient the conversation back to perhaps a disproportionate impact on certain racial groups. So in this way, putting cases like this up on this website and maybe having some commentary, maybe some slides, I think what happened here was today I talked about a case about anti-Asian discrimination, more specifically anti-Chinese discrimination from 1912, anti-Black discrimination from 1936, and a case about discriminatory impacts on women from 2020, and I've tried to connect them for you to show you that there's a way forward in arguing in some of these cases about anti-Asian racism and racism in general. So those are some of my aspirations for having this type of website. It's something that basically we could provide these cases to other educators, and I would look forward to hearing, what other educators have to contribute to this as well.
Thank you very much, Professor Lan, and thank you, Professor Lee. There's very interesting and important dialogue on the way in which education and how education is facilitated at the legal level and beyond is critically important to understanding and addressing anti-Asian racism. Just thinking about these cases, it's self-evident that the law is privileged and as a result holds a significant degree of responsibility in the way that it digests facts, recommunicates them to the public, and in those instances significantly whitewashed the facts before they were then put into court report and thereafter used for decades, almost if it's not centuries in one instance at least, to be taught as legal education. I think back to when I learned R.V. Multani. I didn't even know that it was about a Sikh boy until I met the lawyer who argued the case and told me that he argued it and what it was about. And I was shocked that when it was taught to me, it was condensed in such a manner that it was simply a ratio without understanding the facts and the discrimination that brought that case to the Supreme Court. And so with that in mind, I want to start us off in our Q&A with the first question to both of you. What are some of the challenges associated with teaching about race and racism, and how can we overcome them? Perhaps starting with you, Angela, and then to Professor Lan afterwards.
Of course, thank you for that question. So I think that there are multiple different kinds of challenges that can be presented when talking about these topics. Obviously, for one, there is a potential for kind of tense discussions to occur, whether amongst students or between students and instructors, and it can be very difficult to maneuver through those kinds of situations. And as law professors, there's often very little training about how to deal with those kinds of things within the classroom setting. And so often it's on the part of individual instructors to try to navigate those kinds of circumstances as they arise without having the benefits of real mentorship on that point. And so there are some resources out there about how to facilitate productive racial dialogue in the classroom. Again, that's something that I would hope to include on this compilation of resources that we'll be working on. And another aspect that I think can be particularly challenging is that these are topics that can be emotional and difficult to talk about in that sense as well. And in many ways, the practice of law and even legal education and thinking about law, what it means to think like a lawyer, is often framed as something that's very analytical, something that you need to remove any kind of subjectivity from, remove any kind of emotion from. And I think it's important for students to understand and acknowledge that emotion is very much a part of the law. Race is infused through the law in so many different ways, and that they don't necessarily need to suppress those aspects of themselves when learning about and talking about these things.
Agreed. Thanks very much. Jill, what do you think about what some of those thoughts?
So I agree with everything that Angela just said, and I think maybe I could add a few more. I think one of them too sometimes is there's a lot to teach in a curriculum. So if somebody who's teaching first year contracts will say, I've got so much to cover. How do I fit in anti-Asian racism discussion in there? And so I think the way to think about that too is when we're talking about curriculum reform, that's not necessarily creating entire new courses. It could just be where you could find, and hopefully the resource that Professor Lee and myself will be developing will help by finding, maybe bite-sized little bits that you could fit into a course. Like, for example, I talked about 3 cases there in about 10 minutes. That could be put into the curriculum. And sometimes maybe also professors or teachers don't know where some of those fits would be. So somebody teaching contracts may not realize that, oh, well, for example, both those cases, the Christy versus York, and as well as the one Kwang Wing, they're all about contractual relations, but you could see them in different ways. It could also be an employment law issue. So finding the ways to fit them into the teaching sometimes can be challenging. And I think the other thing that Professor Lee mentioned, I think, is the one that poses a challenge is because of the highly personal nature. So, for example, if I ask students to tell me, have you ever seen this type of clause? Let's say when you go to a bank and if you take a look at their agreement, have you seen that clause and what was your experience with that? People readily will put up their hand and talk about that. But asking somebody to talk about a situation where they felt marginalized because of their race is not necessarily something that students understandably would be forthcoming to speak about in a public forum. Even more so in an age where sometimes we're doing classes on Zoom, where you never know if somebody's recording the class or not, and it doesn't want to necessarily say these things. So creating safe spaces where students can talk about this and still sort of have it feed into the educational experience is, I think, another challenge, because I think it's really important that those experiences come through, because they can really help educate not just the class, but also even the teacher.
Great. It sounds like some of the very key takeaways is seriously curriculum reform, if not reform entirely, but at least reviewing the curriculum that perhaps has been redusted off on an annual basis for some time, in a more material sense than just updating the case law, but looking at the nature in which cases are being chosen and examined, and also the facilitation of discussions. I mean, are there any other key takeaways, particularly for educators, that they can use when looking at these issues in class? They are sensitive issues, they are difficult to address, but not impossible. And are there some maybe key takeaways that they can help with? Whoever feels most confident can go first. Yeah, I don't know, Professor Lee, you want to go first? Or?
Yeah, I can take a crack at it. And I also just wanted to pick up on some of Professor Land's comments, because as someone who does teach first year contracts and does feel quite pressed for time in terms of everything I need to get through, I still do find a way to start with Christy and York. So I center the discussion of contracts around Christy and York, and around how, even when we think about things as so-called private law and as facilitating relationships between people, all of that is couched against a much broader social and political and historic context. And so these things are not aspects that we can kind of selectively ignore. In terms of other things that are useful, I think that being sensitive to issues of race, around gender, around other grounds of difference is an ongoing process for everyone. So it's not something where you just learn about it, you take one course and you're done. I think it requires a constant process of self-reflexivity and examining your own biases, whether these are explicit or implicit, and trying to think very carefully about the various ways in which these may manifest and the ways that these might be received by students. And certainly I would say that increasing diversity is virtually always a good thing. There's a business case to be made for it. It helps make organizations stronger, more creative, so on and so forth. But also I found that teaching at the Lincoln Alexandra School of Law, where we have an incredibly diverse student body, the students have been so much more willing to engage with each other about these topics. And even though they might not necessarily be able to relate to specific instances of discrimination or expressions of discrimination, they can say that, oh, I've seen a similar thing, or a family member or a friend went through something similar, and they're able to kind of find grounds on which they can relate to one another and have more productive conversations that way. And obviously, I think having racialized faculty members who they feel they can relate to and who can understand their lived experiences and their perspectives is also really important and useful.
I think to carry on from those comments, I guess I have two suggestions. One is for educators, it's important to ask the students what they want, what they think, how they feel about these issues, and to get suggestions from them, right? The second one, I think, is related back to what I was talking about before about the curriculum that Professor Lee just mentioned here, which is, this is a well-meaning attempt for professors and educators that feel really tight. I've got like 12 gigantic things to talk about in this course. How do I fit to something in? Sometimes the solution seems to be, oh, well, here's a recommended reading list. So you don't have to read it. It's not part of the course, but I highly recommend that you read it. I'm not sure how persuasive that ends up being. I'm not sure how much of the recommended reading list actually gets read. I would greatly urge educators, even if it's only 5-10 minutes in class, to try to put those 5-10 minutes right into class, even if it is, rather than just put it on a recommended reading list. And like everything that probably usually is discussed in class, that it's examinable material, right? Because if it's important enough to mention in class, and it's important enough to discuss, I think you really send a really strong message home when you say it's also part of the examinable material too, right? Even if it is only 10 minutes of a discussion.
That's interesting. And I think you touched on a very important point there, which is at the end of the day, we're speaking to students, we're thinking about the people on the other side of the curriculum. And perhaps in the last kind of minute that we have here, if we can do 30 seconds each in like a fast-paced round, what is something, how can the students take part in this education from their perspective? This time we'll start with Professor Lan and then end with Professor Lee.
I have a couple, about 4 of them. One, tell your teachers that you're interested in this topic, or administrators at your educational institution. 2, you might organize student events or invite speakers at your student events. You might also, 3, you might incorporate it at your events or on your webpage. And then 4th, if you want to really get a voice in this, in many different schools, there may be something called like a curriculum committee, or some committees where there is a student representative. Right, there are many different schools have, like, you'll have faculty representative, you have staff, and there's usually student representative. So either you are a representative yourself, or you know who that person is, the representative, and you can have them voice their concerns and say, you know, it would be nice if we could have more discussion someplace integrated in the curriculum about anti-Asian racism. So those are sort of, I'm trying to give sort of actionable points, and that's an actionable point where your voice could be heard.
I think that's great. I think you probably told some people a secret there about the curriculum committee, so hopefully it's utilized by the students. Professor Lee?
Yes, thank you. I would say that it's important to remain open-minded. So to remain open-minded to hearing different perspectives, to learning about different things. And to this end, I would also say that I would encourage students to adopt a critical perspective. So even if it's not something that your professor explicitly tells you in class, to start to independently think through the ways in which race might have influenced a decision, to think about the ways in which gender might have influenced a decision, and so on and so forth, because not all professors will necessarily be as versed in these aspects. And this is certainly something that students have the autonomy to do on their own, to constantly think critically about the role of law, about the role of power, about the role of justice, and their part in that process as well.
Thank you very much, Professor Lee and Professor Lan. After all, we are teaching them how to issue SPOT, and so hopefully they're looking into it, identifying it, and critically analyzing from a professor, an academic perspective and a student perspective, the analysis. This panel has now concluded. I learned a lot. I hope everyone else did. We're going to now have closing remarks from Gerald Chen. I'm going to just ask him to please turn his camera on and join us.
Thank you so much, Aaron. And what a wonderful discussion on how we can be active participants in the fight against anti-Asian racism more broadly, in both legal advocacy and legal education. I've had the good fortune of listening to and working with many of our speakers and moderators, and yet I still learn so much by listening to them discuss their experiences and concepts today. And so much of what they said captures the essence of what I've been thinking about when I reflect on my identity as an Asian Canadian lawyer and my role as a justice system participant. I think about the need to be honest about my own experiences as an Asian Canadian, the insecurities and sense of not belonging that I felt growing up, not just as a child, but as a lawyer in the profession. I think about the need to listen to and learn from the experiences of others in the Asian Canadian community, because of course we are far from a monolith. Those who come from different ethnic communities, different socioeconomic backgrounds, those with different intersectionalities, those with different language barriers, those who don't have the privilege of a law degree. And I just loved what Avnish said about breaking down the barriers between ourselves and those who are marginalized and those who we seek to represent and advocate for. And it reminds me so much of what Professor Brian Stevenson has said in many of his speeches in the United States about the power of proximity to those who are marginalized and whose interests we seek to lift up with our legal advocacy. And finally, when I think about my role as an Asian Canadian lawyer and as a justice system participant, I think about the need to use my own experiences as a window into the experiences, not just of Asian Canadians, but all marginalized groups. And not merely to deepen my own insights and to acquire the tools and the sophisticated language that Professors Lee and Lan spoke about, but to also spur me to action. And only then, in my view, can you effectively translate legal education into legal advocacy. Can you act as a meaningful translator, as Avnish said? And the case of R versus Lee that Emily Lam spoke about is such a great example of that, to my mind, given my own experience and involvement in that case. Because there you had an Asian Canadian accused, an appellant who was hanging out in the backyard with 4 Black men, being subject to treatment by the police that would not have occurred, the court found, in a more affluent and less racialized community. The case goes up to the Supreme Court of Canada, and you have racialized lawyers representing equity-seeking associations from a range of communities, all advocating for a common cause of a deeper, more critical race approach to the legal issues involved in that case, such as police detentions under the Charter. And not only did I learn a ton from my own involvement in that case, through my collaboration with lawyers like Emily Lam and Faisal Mirza, who themselves have had such a deep body of experience advancing justice for a range of marginalized groups, but I was also inspired to further action going forward. And that's what I hope that you all have gotten out of the National Forum on Anti-Asian Racism today. And that is a deepening commitment to legal education and legal advocacy, and a richer set of ideas to ground our advocacy efforts so that it can produce more meaningful and longer lasting change. In closing, let me just make a couple points. I just want to give a quick plug to an upcoming event by the International Center for Criminal Law Reform and Criminal Justice Policy titled The Canadian Perspective on Combating Anti-Asian Hate Crimes Under the Rule of Law. That event's going to be on November 16, 2021. So please do try to check that out if you can. There will be a wonderful discussion moderated by Professor Maureen Maloney, QC and former Deputy Minister to the Attorney General in British Columbia. And it'll feature wonderful panelists such as Amy Goh from the Chinese Canadian National Council for Social Justice, Trevor Shaw, the Director of Criminal Appeals in British Columbia, and so forth. And finally, if I could, before we all depart, invite all of our speakers today to please turn their cameras back on so that I won't feel so lonely here by myself, because we're going to try to take a screenshot of all of the participants and capture this for future purposes.
Asking all speakers here to smile very quickly. Thank you. Thank you very much.
Thank you so much, everybody, for attending.